welcome. My name is David Postalski. I am a partner at Gearhart Law, and in conjunction with Gearhart Law and a few other groups, including the Inventors Association of Manhattan, we put on these monthly webinars. We've been doing it for about 2 years. It's usually the last Thursday of every month. It's usually spend lunch with us. And it's all about, we call it the Entrepreneurial Strategy Series. So it's really all about kind of educating you on all the different steps that an entrepreneur will take in various industries, from, concept to, exit type of thing. And so we thought it was about time to kind of do something about infringement. Infringement will happen. It is rampant. And there's really nothing you can do to stop it unless you have the registered form of intellectual property. So for all of you that are, thinking like, oh, somebody's infringing me, like the word infringement, you can only use that if you have the registered form of intellectual property, the patent, the trademark, or the copyright. So for all of you that are still in flux with your, patents or applications or trademark filings or haven't filed yet, the idea is to quickly get yourself on file, because you need to go through the actual application, examination, and registration process. And then once you have that, then thus begins this presentation. And so that's what this presentation is all about: how to use your, patent and trademark, your registered patent and trademark, whether it's in the United States or any other country, and use that as a stick to stop others from coming onto your property. And so we thought it was about time to kind of have a presentation like this. We have two amazing speakers who have really gotten down and dirty with infringement, for sure, because as we say, it's a good problem to have, right? If people are infringing you, it's probably because you have an awesome product, great marketing, and because you're doing something good. And so it's a good problem to have. It could be a difficult problem to solve, but that's what this presentation is all about, to kind of illuminate and educate and empower all of you to do one of many things that we're going to be talking about. So I want to introduce my first speaker. Her name is Cheryl Mosey. She's going to introduce herself, but she's right there. She put her camera on. Maybe you can just talk about yourself a little bit, Cheryl, kind of your company. You don't even have to get into the infringement or anything like that yet, but just a kind of, brief introduction as to who you are, what you're working on, what you've been doing, and all the great stuff you've been kind of involved in.
Sure. Thank you so much, David, for having me. It's nice to see so many people on the call. So my name is Cheryl Mosey, and the name of my company is Minky Blue, and I design organizational travel and work bags. I have a utility patent on my bag, and what's different about Minky Blue than other bags that you see on the market is that I have a shelf in the middle of my bag to help organize and separate your lunch and your shoes from your purse essentials and your laptop. And so I am eager to share my experience about infringement. It's going to be a great and fun conversation. So that's what's happening over here in Minky Blue Land.
Yeah, everybody should check out Minky Blue. Cheryl she's being very modest. You might have, some of you may have recognized Cheryl. She was a speaker about a year ago, I think, maybe a little less than a year ago. We did a presentation. We did a two-part presentation called Reality Show Tales. And so we got winners. We got people from like Shark Tank to come on and kind of talk about their experiences. We also got Cheryl to talk about her experience with America's Big Deal, which was a show that aired on the USA Network, I think last year.
Yeah, in 2021, actually.
Yeah, so you need to. I'm happy to tell it, but I do
Yeah,
come from you.
so let me tell the story. So David and I have been working for a few years now, and he's always gracious to answer my emails and calls. And so we've been working for a few years. I'm always sharing ideas with him and asking him what he thinks about it. But in 2021, I was fortunate enough to be selected as one of four contestants on this first pitch competition show where you have an opportunity to pitch your product in front of America. I had 2.5 minutes to sell America on my idea for my patented bag. And there were three other contestants, and it was developed by Joy Mangano. You may have heard of her. She's the inventor of the Miracle Mop and very famous on QVC and HSN, and she has, I think, over 100 patents. Well, she created this show in 2021 and really was so her way of getting, allowing or providing a platform for small business owners and entrepreneurs. Well, I was one of four contestants. It was the premiere show, the first show. Never have I pitched 2.5 minutes to sell my bag in front of America, but I did it with a lot of coaching from the producers there. There was a live audience and also three judges. Three judges had the opportunity to kind of vie for your product. So there was a judge from QVC HSN, which was Joy Mangano. Then there was a judge from Lowe's. Well, Mickey Blue doesn't fit in Lowe's. And then there was a judge from Macy's. And so I was excited because I had an opportunity to pitch in front of QVC HSN and Macy's. So during that first show and that first premiere, you had to sell at least $30,000 in your product within that hour. And whoever sold the most within that hour, now the show is an hour, but I had 2.5 minutes to pitch. So whoever sold $30,000 proceeded to the next step, which was in front of the judges, where the judges are now, I want you to sell in my store. Well, guess who won the premiere show and the first episode? Me, Minky Blue, Sherrill Mosey, won this show. I'm nervous, but you will never tell if you had watched the show because people are like, you didn't scream, you didn't. I was like, I just wanted to get off the stage, but I proceeded to the next step. And so now it was between QVC HSN and Macy's. I decided to go with Macy's for my to sell my product in Macy's. Now, the thing that I won, which is America's big deal, I won $100,000 purchase order from Macy's to sell my product. And so that was in October 2021. So now I had to go into production and get all of these things ready. And in 2022, October 2022, I had delivered on time the bags to Macy's. So that is the story that's happening now. Do you want me to continue to?
No,
We're going to hold there. Okay,
yeah,
we're
I
going to
think
hold
we should
there.
hold there because the reason why I want her to talk about it is because sometimes fame or being successful, right, causes, oh my God, this avalanche of infringers, and so we'll get back to Sherrill and how she's dealing with that because she is, but it could, I mean, there's no direct link, but come on, people, right? I mean, she was on TV, and she's in stores, and that's fodder for infringers.
Yeah, and I will say that, and we could talk more about this too, because I became very active on social media, and
Yes.
one of my videos went viral.
Yeah.
Over a million people. So in regards to what David says, the more people that see your product, then there's a high probability of infringement.
Yeah. I mean, there are definitely people on this call that are probably like, I haven't even, launched my product, and people are infringing. We'll get to that. And we'll get to that topic in a second as well. Maria, you're going to love this because our next speaker is John Houseal from GIVN. And John, correct me if I'm wrong. We met, it's been a long time. I've known John for a long time. John, we met in, I think you were like one of the early cohorts of FoodX, which was one of SOSV's,
Hmm.
which was the first food accelerator in the world by SOSV. But am I correct, John? I think that's how we met. Yeah.
That is correct. I think I can't remember if we were the second or third cohort of
Yeah.
FoodX,
Wow.
but
We have probably
uh,
crossed paths, so John. I've been here that long.
Awesome.
Fantastic.
John, please introduce yourself to everyone. Who are you? What is GIVN? Your story, please.
yeah. Well, you were just taking me
Yes.
back in time. So very nice to meet everybody. John Houseal, founder of GIVN, as David mentioned. GIVN is a social enterprise where we manufacture consumer products, principally beverages. So we sell spring water, sparkling water. We're launching a series of functional waters. Um, but the basic idea is that for every beverage that we sell, we fund a day of clean water for people in need. So to date, I think we funded somewhere in the neighborhood of 15 million days of clean water. Most of that clean water goes into kind of developing nations, primarily in Africa, but also in India and in Haiti at different points of our existence. So we've been doing that for about 7 years in market. You'll find our products at Whole Foods, I think, in the Southeast, and then at various coffee chains around the US. But yeah, it's very nice to meet everybody. Part of, as we'll get into later, we have a trademark or series of trademarks, but one specifically for GIVN, which is spelled GIVN, and it is under constant assault on all fronts, which is ironic because when I filed for the mark, there was really no competing marks in the space. So very excited to chat with everybody today.
Awesome. Yeah. So I really wanted, John to be on the call because for him, it's all about trademark infringement. For Sharil, it's all about patent infringement. But there's such, they're very kind of, different, but the same type of thing. Right. And so I wanted to break that down a little bit.
Yeah, and I just add, David, I've been
Yes, sir.
for the group. I've not only been on the side of defending the infringement, I've in my other endeavors been on the opposite side where somebody has accused our
You will.
business of infringing on theirs. So I've seen both sides of it.
Yeah, so actually, John, I want to stick on you for a second because you brought up because so as you heard from John, he can kind of expand on it a little bit more. Um, One, he has a registered trademark on GIVN, and he has been the only one on the trademark register in the United States for many, many years. And it's really his. We believe that you have to police a little bit, right? So there's this idea, like so as soon as you get a registered trademark, there's something called watching, where for a few $100 you can watch to see what other people are filing, whether it's a similar mark or the exact same mark, whether they're selling the same product or a different product, doesn't matter, right? The idea is that you want to try to get everyone off of the register, clear everyone, whether they have a similar product or not, right? You might want, in the end, you may want to allow that other trademark holder to exist with you, but it's your prerogative as the trademark registrant that has first that is first, right? You came first. And so, John, maybe you can talk a little bit about that, kind of what like like as a founder, what 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 types of infringements annoy you, right? Are there some that you're like, oh, whatever, or are there some that like, no, I don't go after them? Like, what's your kind of philosophy there? Can you maybe break that down a little bit?
Yeah, I mean, I think we kind of look at it in three lenses, perhaps. I think there are kind of fellow founders slash small businesses that kind of accidentally wade into infringing on our mark. So I think there was some young woman who opened a coffee shop in Knoxville, Tennessee, or a baked good shop and I forget what she called it, but she used GIVN and then something else. And, in those instances, we generally try to just reach out and kind of explain that, that's our intellectual property. And in most instances, or probably all of them today, it's a pretty easy resolution. They didn't know anything about IP, and, they kind of adjust and move on. On the kind of moving up the chain, there are a number of kind of what I'll call fellow social enterprises or nonprofits. And so as we look at potential infringement in those cases, we try and balance confusion in market versus not just operating kind of a standard program where we're going after anybody that gets close, because we're very supportive of other charities and what they're doing, and we're not looking to generate a bunch of friction. So to the extent that how they use a mark that may be similar to ours, we might choose to overlook it. In other instances where it is confusingly similar, we might approach them and generally try and engage them in a dialogue that may result in coexistence agreements or other things. And then our third group is kind of the people I really hate. And it's just really specifically one infringer. But for the longest time, GIVN.com was owned by a company called GIVN Imaging that was purchased by Medtronics, who basically allowed the domain to disappear into a dark closet and never did anything with it. When it finally came out of that closet, somebody had purchased it at a domain auction, and then turned around and wanted to sell it to us. I think they paid $6,000. They wanted to sell it to us for like $300,000. And they really didn't have any business behind it. They subsequently did create a business to try and defend it. But in those cases, it's a little more aggressive. And for us, is still a fairly small business. It's balance. Even, you want to kind of squash them and make them go away, but it's exceedingly more complex than that. It's also very costly. So it's trying to find a way to balance all of those factors as you look to retain what you feel is, rightfully your intellectual property.
I love that, John. I think you brought up some really good points. Like these kind of decisions to go after infringers. Again, I think you'll hear a different take from Sherrill, but when it comes to branding, yeah, it does fall into these buckets. Like, do I really want to squash everyone, especially someone that's just like me? I will say this, John and I definitely discussed in detail when one of these potential infringers potentially pop up. We kind of look into all the things that John was talking about and have a kind of have an open discussion as to whether we should be going down this path. Because John is right. A lot of the times, if you are going to go after everyone, even the fellow social enterprises, even the fellow founders, a lot of that can blow back in your face, right? This is a social media world, and sometimes sending a cease and desist letter, just putting them on notice or something, hey, can you stop, or whatever, fellow founder, that stuff can creep its way into social media, and then you're labeled as a troll, even though you're just trying to protect your property. And so it's good to give some thought to it for sure. And so I'm kind of putting it out there because all of you as founders, or all of you that are dealing with founders that deal with infringement, this is an emotional decision to go after someone, but it's also a business decision to go after someone. And no matter which way you cut it, it's an expensive decision. And what I mean by expensive, not so much the dollar price. Yes, it can be costly, but I'm talking more about like expensive in the fact that if you decide not to go after the infringer, right? You're not going to go after them. You're going to let them coexist with you because you don't want to, they're selling maybe something slightly different or whatever. That will chip away at your brand, right? That will chip away at the strength of your brand. So maybe going after the next one might not be so easy for you. So keep that in mind. There's that. So that could be an expensive problem. and then on the other side is, okay, going after them full force, which might involve like litigation, or maybe inside of a court or inside the trademark office. That has a cost to it as well. And so just to kind of balance that out in every situation is what you have to do. Sherrill, different for you, right? Different for patents. So like nobody, to date, I don't think anyone's infringing Minky Blue, your trademark, but this is all about the patent for you. So what's your kind of philosophy on this?
Yeah, so I had mentioned that one of my videos went viral last year and it got over 1 million views. So I was getting um, comments and messages from people all around the world, from India, Dubai, Japan, all around the world. And I was like, oh my God, I know somebody is going to copy um, my product, my bag. And so I hadn't up to this point sold on Amazon, always afraid to sell on Amazon because of the obvious reasons. I mean, it's notorious that when you sell on Amazon, you have a product, people just copy, they just just copy your stuff. And so for a long time, being a small business, I knew that if I put my stuff on Amazon, I wouldn't be able to keep up with making enough products if somebody copied. So I stayed back because I was too small. Well, once that video went viral last year, my heart sank. And earlier this year, you have a website, you have a product, and you do your best to sell your product from your website. But the way the world is now, and you can think about yourself, is that we go to Amazon to buy just about everything now. And so people may come to my website, but they're going to go to Amazon and put in Minky Blue. So I went to Amazon, I put in the name Minky Blue. Before I could finish typing Minky Blue, it was popping up. Not only was my name popping up, but the names of my bags were popping up. So I have the Ella Toad and I have the Mariah backpack. So the names were popping up. So I'm digging around and I see backpacks infringing on my patent, which is, and I'll just show you guys, I'll show you what the difference is. So we have a regular tote bag right here. And then the patent is actually on the shelf right in the middle of the bag, which I can unzip this shelf and open it up and it becomes one big bag. So that's the patent, is that it's the functionality of being able to convert the bag. So now I'm on Amazon and I'm seeing backpacks that are infringing on my patent with that shelf. Because on Amazon, the suppliers are going to give you images of how it works and how you can use the bag. So I'm like, oh my God, what do I do? What do I do? Reached out to David. He was like, I don't know. It's just Amazon. That's just how crazy it is. So in all of that, and there were a number of suppliers, not only of that, my bags, I actually manufacture overseas. But they are expensive for me to manufacture. By the time I manufacture overseas and bring them here, there's just so much, so it costs so much. The suppliers on Amazon are the manufacturers. They're in China. So they're selling their version of the backpacks for $39.99, $49.99. I could never compete with that because of the labor and putting a shelf in the bag and all of that kind of stuff. So it's very expensive. And David, you can come in any time. I don't want to.
Yeah, no, go for it, please.
Okay. And so I was trying to figure out, how do I deal with this? Because people can buy this bag for $39.99. My bags are a lot more expensive. They are $170. They're $200 because I need to make a profit, and it just cost me a lot more than $39.99 to make the bags. What I decided to do is I did some research, just spent some time just figuring out how can I go after these suppliers, which I just thought was impossible, David and I both, because Amazon is notorious for that. What I learned is that last year in April, Amazon actually launched a new program called APEX. APEX stands for Amazon Patent Evaluation Express Program. And what it is this new program that they set up to protect US patent holders against companies that you feel are infringing or copying on your patent. Well, who knew? It wasn't even a year old when I decided that I was going to contact them and apply for this program. So in applying for Apex, I had to submit a copy of my patent along with only one claim. My patent has 11 claims, so I had to go through the patent and figure out which claim would cover or my best chance for them to review and say, okay, we agree with you. So I submitted my patent along with the claim number to Amazon under this Apex program. This program it was so fast. Within 30 days, I was approved I was approved, and for my patent was approved under the Apex program. So now that means I can submit all of the ASIN numbers of companies that I feel that are infringing on my patent. I submit those ASIN numbers, which are the ID numbers of every product that's sold on Amazon. So I submit that ASIN number along with my approved Apex ID to Amazon. They have an independent reviewer, intellectual property lawyer reviewer, and then they will in turn reach out to the supplier and says, hey, you're infringing on this patent. You can either contact the company that is putting in the claim, which would be Minky Blue, or we take you off. Now, when I first knew about this and saw that all these companies were infringing on my patent, the first thing I said, I want to be the only one to sell on Amazon. I wanted, listen, John said, or somebody said, I want to squash them. I don't want anybody else selling Minky Blue patented bags with even though it looked different, I didn't want anybody else selling and using my patent. I wanted to be the only one. I wanted to dominate. But then I was like, you know what? Wait a minute. I'll never be able to make my bags for $39.99 or $29.99. It just, I wouldn't make any money. I said, let me think about this for a minute. What we decided to do, I talked to David, and he was like, well, yeah, let's just go for it. I was like, you know what, David? How about if I allow these suppliers, these manufacturers, to sell their products for $39.99, because I know I could never sell it for that, but they pay me a licensing fee, a royalty fee. And Dave was like, yeah, let's see what happens. Let's go for it.
And it worked.
And it
worked
worked.
over and over again. Yeah.
So now we are monitoring Amazon to figure out who's using the patent. I send the ASIN into Amazon, so they will either remove the supplier right away, I think within 3 days, or either if the supplier wants, they have the option to reach out. When they reach out to me, I pass them on to David. David contacts them and say, hey, you can stay on if you pay us a licensing fee, a royalty fee. And we based it, we came up with our formula. We didn't know what we were doing at first, but we came up with the formula. We were like, well, how do we charge them? How do we look at this thing? And so we decided to get reports, Amazon reports for how much they've sold in the time that they've been in business. And we base it off of that. So our first licensee, and I currently have 4 right now. So we probably took off, I would say, up to 18 companies now. We have 4 now. And when that first company dropped like 20K in my bank account, and we didn't have to do anything but just basically get them to say, okay, we're going to pay you 20K. So we asked for an upfront fee, what do we call it? An upfront.
Well, kind of lump sum payment to kind of, address all the previous infringements that went on, right? Like, hey, you got to pay for that, type of thing. And then going forward, we devised a royalty structure. Yeah.
Yes. We devised a royalty structure, which is paid out quarterly. Yeah. So now I send little reminders. Hey, your quarterly payment is coming up. Make sure you put that money in the bank by the deadline. And David, we tried to structure where everybody is paying at the same time every quarter. And I'll send little reminders, and they know, because it's in the agreement, that if they do not pay, then they just come off immediately. And so that's, I turned that thing around to make some residual income while I'm sitting back, sipping my cup of coffee and watching them put that money into my account. So sometimes, you can be creative, depending on your product and your situation, and kind of think of how you can be creative and earn with your strategies to actually benefit from someone infringing.
Yeah, let's break some of that down. Chris had some good questions. I want to answer them. First of all, for all of you should know that this is Amazon US. There are 8 or 9 other Amazons, and they all work the same way, but you need the corresponding patent in that particular country where the business is actually happening, where the actual infringement is occurring. And so I do believe Cheryl only has a US patent, so this is all playing out in the United States. Amazon is the only site to date, and it's a big deal, the only site to date to protect the rights of intellectual property owners through their through their patent program and through their brand registry, right? They're the only company, not Etsy, not Shopify. So again, if you want to do business there, they might have some terms and conditions. Oh, let us know if somebody's infringing, but nobody has done it the way that Amazon has done it. Props to them. But like I said, Amazon is the largest department store, and there will be the most eyes, and you will have the most problems, but hopefully it will be worth it in the long run, like it is for Cheryl. Now, Cheryl, it's interesting. Usually when you bring she sent in her patent, and she took the representative claim, and somebody at Amazon, a patent attorney at Amazon, said, you know what, there is infringement. Great, she was accepted. That's something that not everybody sells on Amazon. And so usually if somebody comes to us and says, I think somebody's infringement, I think there's a few people on this call that we've helped this with, we do an analysis to see whether the product or the patent that you believe might be infringing you is actually infringing. And so that's called what we call a freedom to operate search, or an infringement opinion, or an invalidity opinion. We do those searches, and sometimes, we do those opinions, and sometimes they may come back like, not really infringing. That doesn't mean it's the end of the story, right? Because you can just kind of moving back to John, you can send a cease and desist letter, and it may not be the strongest case, but sometimes that does the trick. And so sometimes after we do an analysis, know what your strengths and weaknesses are, then send a cease and desist letter. I'm not talking about suing anyone yet. Send a cease and desist letter, lightly threatening to sue them. They sometimes go away. So she really didn't have to do any of that. Kind of Amazon is taking care of that for her through this program by allowing these people 30 days to respond. You want to challenge it? Great. And I think, Sharil, I think we've talked very openly about it. At some point, there might be a company that will challenge it in Amazon in that program. And they might hire their own firm and they might say, we are not infringing. And that probably will be a very non-public situation. So even if Sharil can't come up, if we can't come up with some deal with them or some settlement with them, okay, they continue to start selling. And then like back to John, so now you have a company that is selling and you can't do anything about them, that begins to chip away at your protection a little bit. So I think the lesson here is that not all battles have to be fought, but the battles that are fought, hopefully you're going to win. And if you don't win it, it might actually be kind of costly to how strong your intellectual property is.
And you know what? And I will say that for the Apex program, you don't pay up front unless someone challenges you. If they challenge you, then you have to pay $4,000. Yes. And then it'll go back and forth.
Yes, that's correct.
Yeah.
Okay. So I think I answered most of the questions. I think they were really important. Hang on one second. Okay. John, like, can you talk about, so I think we touched on it a little bit, but like everybody's always, how do I find out about infringers? Like, are there things you can do? We talked about watches. Maybe you can talk about that a little bit, but like, what else can you do? Any kind of, strategies, and maybe you can talk about the relevant cost to it, if there is a cost to it.
Yeah, I'd say for it's kind of a combo. I think it's for folks that are seeking to register a mark, obviously our monitoring service is the primary vector where we discover potential infringement. The other place is just generally through word of mouth or referral. Occasionally we'll do periodic searches, on Google to see, who's using that term, in part just researching our own marketing, but in part, occasionally we discover something else. But then also we'll have friends, family, customers, they'll, flag an item. I think that coffee shop in Tennessee was flagged by, one of our customers at some point. So it's a variety of mechanisms that we use, but principally probably the most structured mechanism is through the monitoring service.
Yeah, so just a little bit about that. So yeah, so there are these companies that will do these worldwide trademark watches, and they will flag anything that has been filed anywhere in the world or that has recently passed examination, meaning they passed, they're about to get a trademark. You now have the opportunity to oppose them or challenge them. And that's kind of where we kind of swoop in sometimes. The best strategy is to try to catch the infringer as early as possible so that they haven't spent any real money on their brand. And that's the same thing for patents too. At the end of the day, we look at that. If somebody just filed for a trademark but is not yet using it, that's really when we want to strike, right? Because then they can't come back to you and say, well, I spent all this money, I have all this branding, I bought a domain name. Okay, you haven't really sold anything yet, you haven't branded it yet. That's the real money. So it's very easy for you to kind of step to the side. The moment they are, full-fledged businesses that have put some money in, it becomes a little harder. So these trademark watches is something we can do, but John brought up something good. Google alerts, right? Pretty free. Anytime there's any mention of your trademark or something similar to your trademark, Google can let you know, and that's when you have to swoop in. John, can you talk a little bit, because Sharil hasn't yet used cease and desist letters, but you have.
Yep.
Maybe from your perspective, you can kind of let people know what those are and if you think they've been effective.
Yeah, I mean, I think so cease and desist letter is pretty straightforward, is what it sounds like. I think generally we have, David and company draft them for us, but it's, sending formal notification that, we've identified a potential conflict or infringement and that we would like for you to stop. I'm trying to remember, there's a variety of contexts in which we use it. A number of times if we can't get a hold of them, I think we, as a general philosophy, if we don't view the infringement as a bad actor, somebody acting in bad faith, then we reach out in good faith, informally prior to issuing a cease and desist letter. But if that conversation doesn't go well, or if we're unable to get in contact with the individual, we use the letter as a formal mechanism to let them know that we are displeased by their use of whatever mark it is they're looking to put into the market.
Yeah, so John brings up a good point. I think there was like a situation I remember years ago. Usually when somebody tells me, especially when it, not so much when it comes to patents, but when it comes to trademark infringement, and somebody brings it to my attention, I usually say, are you sure you want us involved? Because that, getting an attorney involved and sending a cease and desist letter is a power play that works, but could also blow back in your face. And I'll explain that in a second. So usually I'll say, okay, John, is there something you can do? Maybe, reach out to them on social media, or kind of direct message them. Sometimes, entrepreneur to entrepreneur, they'll stop. If they don't, then yes, a cease and desist letter. The reason why any of this, I think, just to put it out there, the reason why, dealing with infringers can kind of blow back in your face is because most of the time when somebody's accused of infringement, whether it's through a cease and desist letter or litigation, the first thing that they're going to do is not say, okay, I did it. What do you want? That doesn't happen that often, right? And so the first thing they're going to do is try to prove that your intellectual property is invalid. It should never have been registered, right? You never should have gotten your patent. You never should have gotten your trademark. That's what they're going to do. That's the defensive they're going to do. And so you really have to know that you have a strong case, or you really have to know that the people that you're going after will not fight you back. And that you never know. And so as long as everybody's kind of realizes that it's not just like sending letters out and people just, bowing out. Sometimes it's real force is necessary. So just keep that in mind. Somebody asked if there's patent watching. There isn't. But what we can do for patents is we usually do a search, like we do an updated worldwide patent search to see what patents have been granted or filed that come after your filing date. Right? It's all about It's all about that filing date with patents. And so then when we identify who those companies or those products are, then we do that opinion I was talking about to see if it's even worth going after them. And then we kind of move to the next step. So there's that. So Sharil, you haven't dealt with any of that yet, right? On Amazon. You're kind of like in a little bubble there at Amazon,
Yeah. But I got to get ready. So I'm glad I'm on the call too.
Yeah.
I'm on the call too.
For sure.
So.
And 1 second, just looking here. Yes. So someone had put in a great comment that when you have the patent, or the trademark for that matter, when you have the registration, there is the presumption that it's valid. And that's the great thing. I say that all the time, right? You're valid, right? But at the end of the day, you still have to prove infringement, right? You still have the other party still has to prove that they're not infringing you, which is great. But at the end of the day, and let's be very honest. I mean, I'm saying this in all honesty, as a patent attorney, sometimes the patents that the patent office grant, just based on the examination and the back and forth, they may not be as strong, right? The patent office makes mistakes, right? There's millions of patents in the world, and so they only get a few hours on each, and so that's why patent examiners are constantly trying to reject you. They're really trying to cover your ass so that in the future, one day, when you bring a patent infringement suit against someone, that there's not going to be this surprise, reference or patent that the patent office should have looked at. And if they would have looked at it, you wouldn't have gotten your patent. That's what the other side is going to try to do. That's what the other side is going to try to prove. And so that's the kind of analysis that we're doing all the time in terms of infringement. Can we talk a little bit about cost, Sharil? I mean, you talked about kind of what you got, but like, I mean, just some general thoughts about cost. Is all this worth it? Like, I'm just curious, kind of, has it been expensive? And this is not a reflection on us, but just in general, like with your business, like, is this all worth it? That's really the kind. You can talk numbers if you want, but really, I think people want to know, is this fight worth it? Because it does cost money.
Yeah, I mean, for this particular process, it definitely was worth it. The only thing that I paid, fortunately, thank God, because nobody has challenged me, because they're sending the patent to the supplier, and I guess they're looking at it as well. Because nobody has challenged me and said, we don't think we're infringing, then I haven't had to put up $4,000 at all. And we've reached out to over, I think over 20. We have 4 now. So the only cost really is my time to research and, go back and forth, and for your services.
Yeah.
So what I've gotten out of it has definitely been worth it. And you think about in perpetuity, as long as these guys are selling, then I'm going to get licensing and royalty fees. So it's definitely been worth it.
Okay, that's good to hear. John, what about you? Kind of looking back on all these years, we've managed to stop a lot, some easier than others. In the end, has it been worth it to you and to your brand?
I certainly think it's been worth it. It's an area that, the newer you are, it it feels expensive, but over time, as the business grows, it really becomes a standard component of your budget because, as you build the brand, you have to defend the brand.
Yeah.
You don't want to put all the effort into it and then have somebody come along and then just start using it and building off of it. So overall, it's definitely worth it. And I mean, I think as you have seen, but for the group, I'd say we're investing more than ever at this point in protecting our brand. Um, so it's certainly a very important component of our business.
Yeah, it's definitely the cost of doing business. I think everybody has to kind of come to terms with that. That once you get your patent and your trademark, it just doesn't stop infringers. I hear that a lot sometimes. Oh, I got a patent trademark, nobody will infringe me. That's when the problem starts, and that's when you can do something about it. But yeah, it should kind of factor into your budget. John, have you had to this? This is kind of related to a question I saw from Mark Anton, and it's a good one. I know you primarily do business in the United States, and I don't think we've ever dealt with this, but do you kind of look out to see what's happening internationally? Like, are you like, have you dealt with that issue before? Like, kind of international infringers?
We have not. We do have our mark patented, trademarked in the U.S. and in Canada.
Right. Yeah.
We did not go for the international registration at the time. I think we had missed the window to get kind of, going all the way back. We were doing our own IP internally for quite a long time, which was its own fun experiment, including actually having somebody who we did not like getting their mark canceled, which is when we then went and got David's help because we didn't know what to do after that point. But yeah, I mean, we keep an eye on it, but for the most part, we're focused on North America.
Yeah, and but so that thank you for that. But Sherrill, it's funny because you are dealing with international sellers, right? These are
Yes.
foreign companies that are registered marketplace sellers on Amazon. And I would say all of the situations, correct me if I'm wrong, they're non-US entities at this point.
Yes.
Yeah.
Yes. So I can only protect the patent for the US. So that same foreign entity can take the patent, take the product, and sell it in Europe and anywhere else in the world. And I can't do anything about it because I don't have a patent in those other countries. And would I want to go after that? That would probably cost me, and I would probably I can't even deal with that. So I'm just going to deal with the US, and that's all I can do.
Yeah, I mean, Mark, that's just sometimes that's just sometimes the protection you have to give up. This is a territorial intellectual property system. Wherever you have the patent or trademark is the venue that's your property that you can protect from. That's the courts that you can get into if you have to go to a court. Um, but if you don't have it, just Cheryl said it perfectly, if you don't have a European patent, then there's nothing you can do about the European, infringers. You can sell alongside the European infringers, and you won't be able to do anything. Either party won't be able to do anything to each other, but you won't be able to do something about it. On the trademark side, I have a client that only has stuff in the United States, and a lot of the infringers that we go after are they're basically wholesale. They kind of manufacture in company in like India, let's say, and then work with distributors in the United States. And so when we go after them for trademark infringement, we are not just we're not just serving in court the actual distributor, but we're going after their parent company in India, right? We're serving them in India. We're demanding they appear in a court of law in the United States. And so that's kind of how the system works. Because at that point, that company is doing business. They're doing business in the United States from that hypothetical. Court. So let's talk about court a little bit, right? Because this is all like Amazon is not court, right? But sometimes you have to go to court, and sometimes you have to go to the federal district courts, which is a patent or trademark is a federal right, and this is like two courts under the Supreme Court on the federal level, not on a state level. You bring the suit in a state, but it's in a federal court because it's federal intellectual property rights. That is usually the biggest power play that you can do, right? That's the coming out to the jugular, right? You're not sending maybe you sent a cease and desist letter, maybe you didn't, right? Maybe you tried to reach out, but maybe you didn't. That is the only way, truly, that a company has to respond to you. They don't have to respond to your emails. They don't have to respond to your direct messages. They don't even have to respond to your cease and desist letter. I tell people all the time that cease and desist letter, we can rip it up, right? If I got it, and if somebody said my client is cease and desist letter, and I would say to my client, we could respond if you want, but we don't have to. Nothing is forcing us to. We're not going to lose anything if we don't. Chances are we will respond to it, but we can literally rip it up and wait for that person or wait for that company to file a lawsuit. That's something you have to respond to. You cannot avoid that, because if you don't respond to it, the court will just assume that you're kind of guilty of the charges, and then they will issue a judgment against you. And so, John, you want to talk about that a little bit? I mean, I don't think we've been involved with that in like a federal district court, but anything you can say to that, just from some of the experiences you've been through in the past?
Oh, let's see.
Only things only things you're allowed to say.
So we do have experience, ironically not related to marks, but related to patents, having patents canceled, both by the trademark office and by the federal, well, I should say the federal court affirmed
Yep.
the trademark office's ruling. And in that event, what had happened, and it goes back to your question, you got to be careful, pick your battles. For a startup where I was the chief product officer, we had one of our partners, we had a bad relationship, everything fell apart, and they took us to the trademark office for infringing on their patents. The patents weren't theirs, they had acquired the patents. And then through our legal efforts, we were actually able to find a patent that existed about 15 years prior to theirs, and prove that to the court. And so that nullified their patent because it should have never been issued. And the net result of it was they lost their patent and they lost their suit against us. And we were able to prevail. after they lost in both in the trademark court as well as um, the federal court, they then took us to state court for breach of contract under IP that they no longer owned. And so, what I can say, I think the important thing to take away from there is just because you have a patent or a mark doesn't mean that you're going to prevail when you bring a case. In this case, I happen to be on the better side of that experience, but it's certainly a consideration anytime you think about, moving forward with kind of litigious process or litigation. You really got to have some deep thinking about is it worth it, and are you comfortable with what might happen coming out of it, because the discovery processes are pretty extensive. When you get good attorneys like David involved, there's going to be some extensive research that could turn up things. For instance, somebody might have been using GIVN back in 1985 for chocolates or something. You never know what's out there. So just because you have the registered asset doesn't, mark or patent doesn't necessarily mean that it can't be undone.
Yeah, well said. Yeah, well said. Any questions for?
I see David Simpson had a question in here in the chat. It says,
Yeah,
any advice for the inventor that licenses their patent to a third-party manufacturer to commercialize, then others infringe on the patent? What do you say, Dave?
Yeah, David Simpson asked that. So you are an inventor that's licensing your patent to a manufacturer, and then somebody's infringing you, right? That's kind of what's happening. Okay, so first of all, a few things. One, the ultimate responsibility to bring a suit for infringement will fall with you as the owner of the asset. However, in your agreement with the manufacturer, there might actually be some clause there that says that, oh, they will, that they have the ability and the right, and what we call indemnification, things like that, where they will bring the suit and you will help them, or you'll split the suit. So that's why those clauses are really important. That's why in licensing deals, that's why it's really those indemnification and infringement clauses are super, super important. But ultimately, it's going to be you, right, as the owner of the asset. Whether the manufacturer may take part, especially if they're really like bringing the product to life, if you will, right? Because you could just have a patent, great, but as part of the deal of them bringing it, of actually bringing it to life, you probably want them to share in some of that responsibility if there was an infringer discovered.
Dave, would it be important for you to do another search before you file a lawsuit? Like, go to a good lawyer like yourself, say,
yes.
Dave, here's my patent. Like, before suing, you would probably do another search.
Yes, that's why. So Jock, yes, 1,000%. When someone comes to me and says, especially for patents, when someone comes to me and says, we think that somebody's infringing, okay, thank you, but we need to do a search to see if there's that smoking gun that could knock your patent out, because that's their defense. And so, yes, we usually do those kind of analyses to really see whether your case is strong. And I will say this, and there are people on the call that have been through this, you may not have the best case, right? It may be some weakness, right? Not every case is slam dunk, but sometimes, I hate to say it, but sometimes the strongest case doesn't win in this world, right? It's sometimes who has the most money, who has the most patience, who has the biggest balls to come out with the biggest power move, So that's
also the conduct. The party's conduct is important. Like, if you're trying to transfer a patent to an Indian tribe, the court's going to consider that.
Yeah, that's a good point. Your conduct is definitely, when it comes to infringement, it doesn't have to be intentional, right? It could be like, I didn't know. I didn't go at him. I just didn't know. Right. But if it is intentional, like if there is some intent or malice, then the court will look at that and say, you know what? Not only were you infringing, but you went out of your way to infringe, right? You knew, right? That's why those cease and desist letters are sometimes so important, because it puts the party on notice, right? Puts them on notice, like, hey, we're watching you, we're looking at you, right? We're going to do something about you. And then when the court reviews all that, they're like, wow, for 3 years they knew about it and they continue to do it. We're going to punish them, right? We're going to assess punitive damages. And that's why intent sometimes matters.
Well, you never want to get to that point, but it seems like a patent has to be novel. That's the first aspect. But then after that, it has to be used correctly. You know what I'm saying? It's a privilege. First, it has to be novel, never been done before, useful. But then after that, it's a privilege. How do you use it? Do you charge too much? Do you charge ridiculous amounts of money? Like they did for some of the genetic tests and all that. The court considers that.
Agreed. Jock is bringing up amazing points. And Sherrill kind of touched on it a little bit. Sherrill wasn't really selling her bag. Correct me if I'm wrong, right? You weren't really selling your bag on Amazon at the time that you complained to Amazon that there are infringers of your patents.
Right. I was in the process of uploading it. So no, it wasn't being sold at the time.
Which is interesting, because sometimes when you go to a court of law, right, the court will say, okay, you know what? We believe that somebody's infringing you. But the next step that the court looks at is damages. And if you have a product that hasn't been sold, right, how do you really create that damage valuation, right? You have to get experts involved. It's hard. If you were selling your product already, you were selling it in the right way, to kind of use your words, Jock, then it becomes easier for the court to understand what the potential for damages and lost profits were, right? So, and that's the same thing with trademarks. Same thing with trademarks also. If you just have a trademark and you don't have any business, no business attached to it, yeah, we might be able to stop someone, but getting damages from them is a whole other issue. It's a separate issue in a court of law. And so sometimes the case is so clear on infringement, right? That's the easy part. The easy part. But the damages, the court will be like, you didn't really sell anything. So how'd you lose profits on what exactly? Oh, they were making money that you should have made. Okay, maybe we'll give you some of that. We're not giving you all of it, right? You didn't do anything. You didn't do anything with your invention, So yeah, keep that in mind. That's a big, big part of it. Thank you, Jock. Anybody else have any other questions?
Welcome. It's a fascinating area of law.
Yeah.
Fascinating area of law. It really is.
It is, yeah, for sure. Yeah, for sure. Any other questions for Sherrill or John? I think maybe if there are no other questions, maybe in closing, Sherrill, maybe you can just kind of like maybe give some kind of words of wisdom for everybody else that's on the call on kind of how to kind of deal with all of this.
Oh, we're all, I think when I'm speaking for myself too, it's hard dealing with this because we're always fearful of, first of all, fearful of sharing our ideas, right? Because then that holds us back from even making a product. And then we're fearful of someone infringing, and there's nothing that we can do about it. But if we start thinking about ways of thinking about how can we turn this around so that it'll benefit us, then kind of relieve the feel. Okay, this is so scary and I don't know what to do and it's going to cost me a lot of money. Kind of think about the flip side of it, to remove some of the barriers that we always keep and hold in that keep us from moving forward on anything that we do. So kind of, the restructuring the way or rethinking the way how we proceed with things, and not always, because fear will keep us from doing a lot of different things. So hopefully, and hopefully that helped some way. Yeah. I don't know.
Those are good words of wisdom. Fear could be kind of paralyzing, right?
Yeah, absolutely. There you go.
David, can I ask an attorney question?
Yeah, and then Matt, go for it, Chris.
You, as an attorney, from your position, you find it's easier to defend and help an inventor who has a continuation filed on their original application, or versus having an issued patent and no continuation?
I love this question. So I always, and this goes for this, the question was about patents, but it also applies to trademarks. I'm a big believer in not, and this go again, Sherrill, this is not you per se. It's crazy that you're really really an anomaly in the best possible way. Most of the time, I suggest don't rely on just one patent or one trademark, right? It's very easy to go around, jump, left, right, go under, this, that, right? Create a different whatever. And so I recommend having like a portfolio that you can have, like multiple trademarks, multiple slogans. And then on the patent side, yes, we always say be your own improver, right? So think about other ways that you could improve your own patent, and you file that as what Chris said, a continuation. And then you begin to build this fence, right? So if somebody doesn't infringe that, they're infringing something else, and they're infringing that patent and not this patent. And that's the way it is. There's no requirement by the patent office that you build exactly what you patented, right? So you can, be your own innovator and include all of the different variations and versions and changes and embodiments and future iterations and whatever. And you put that into your portfolio so that you make it even easier for someone to infringe you.
That's good. We haven't talked about that. I got to build my portfolio.
Yeah, you too.
Hello, hello, David. Excuse me, David. Mark Levine, architect with a copyright design. Can I ask a question?
Yeah, of course. And then Matt. Go for it.
It was great. It was great to be on the meeting. And Sherrill, I was wondering how you decided on what to charge as a licensing fee, because is it a percentage of the bag? Is it how is that done? Because I'm in a situation where I've actually had someone at a meeting actually come around and say, what happens if we use, quote unquote, your design and not pay you?
Wow. Wow.
So,
yeah.
And it's very hard. These people have deep pockets that develop anyway. I won't go into it. But rather than get into that, I was wondering if how you structure a licensing fee and what do you charge?
Yeah, so there's no one size fits all fee for every company. And so what we've done, like most of the companies that most of them, I only have 4, they're really small. They're small companies, and we can see it based on their sales. So because they're small, it's different. Each company pay a different fee because we base it on what they've sold in the past. So some, when you think about Amazon, you think these suppliers are selling thousands, which some are, and they're making a lot of money. But then there are others who are only making, who are only selling hundreds, maybe a few thousands a year. So we look at what they've done. So we started doing a flat fee in the beginning because we were just trying to figure it out. And we were looking at what they've sold in the past. And these are really small suppliers. Then the last one, we really tried, I said, okay, David, let's see if we can get a percentage. And so we really tried to do the percentage route without really knowing the background of the company. And so for this last company, I started doing a little digging, David, even after we signed the agreement. And I found out that this is a pretty big company, but I didn't know that up front because what we found is that they send these names, which I won't even get into the names, but they actually we think that it's one store, but it turns out this company may own 5 stores on Amazon. And I don't know that, and I don't see that. I only see the one store. So I think the bottom line is before you do that, maybe and this is a lesson learned for me, is to do a little digging in this company, in the company that you're working with. How big is the company? You just said that there's deep pockets. Then you can ask for whatever you feel like it's worth, and then you negotiate. Always leave yourself room for negotiation. Yep. So the thing of it is there's no one size fits all. I look at the size of the company, what they sold in the past, and then put it out there and negotiate. David, you want to say something?
I was just going to wonder, what percentage of the bag did you charge? Was it percentage of the 170 that they would that you charge, or a percentage of their $40 bag?
Good question.
It's percentage of what they are selling.
And what percent did you use, if you don't mind?
We tried to, on this last one, was it, did we say like 6%? David, I can't
7% or something. I think it was 7.5%. Listen, I can't recall your name that's asking you the question, but I think Cheryl straight up has been pretty fair with them. She's provided some really, deals that you can't refuse, and that's probably why it's been so successful. And for her, it's just pure profit, if you will. But I think Cheryl said it best. There's no one size fits all. There's a lot of different ways to cut this. It could be 7% of their price, or 7% of Cheryl's bag's price. It could be just some random number. It could be, after doing some research, you can do some research on industry, maybe it's 2% or 3%. We didn't want to get into much negotiation with them, and so we were trying, and we also wanted to appear fair, right? So that's something that Cheryl wanted, and I respect that. I'm not one to, I didn't want to blow the whole thing off, because remember, they can just say, okay, we're not going to sell anymore. And that's it. It goes away. But at least you can make some money from it,
And the beginning part is a learning curve. So as we learn how to structure the deals, I can change it for the next one and go even higher and see what people will accept.
Yeah. Matt.
Thank you, Cheryl.
Yeah, I get to go. Okay, great. My question is about trade secrets and the relationship to trademarks, because I've been approaching my IP development in joint ventures, and then I created some incredible results only to have the other guys steal them. So now I'm considering, litigation options and so forth. So anyway, I always compare what I do to 11 Secret Herbs and Spices, the Kentucky Fried Chicken, and Coca-Cola, where nobody gets the whole recipe, right? But I was wondering, when you talk about trademark, are you delving into the area of using a franchise model, whether you do a formal franchise or not, but to protect the trade secrets? So you got the trademark tied to the trade secrets, tied to the product, tied to the results. So there's like a continuum of trade, of IP protection. I won't go for patents anymore, because a patent partner of mine blew through like $10 million before he lost everything. So I won't do that anymore. And
I'm so sorry for you.
It was, I was part of it, but I forget about it. But the main thing is, I don't want to give anybody my instruction book.
Yeah.
So if your patent's not enabling, right, it's not valid. So why would I want to tell somebody what I'm doing? But the thing is, I'm using multiple systems, multiple data flows, a lot of things to help people to put joint ventures together that help them get better results. So what I've been doing is like a franchise model for protection. Have you heard of something like that, where essentially you don't have to really build a franchise, but you have to use that model? So it's like a licensing model.
Yeah, definitely. So I think, just to make it clear to everyone, a trade secret is the opposite of a patent. It's not public. No one will ever see it. And the only protection you have is if you have some sort of agreement, or whatever you want, non-disclosure, franchise, joint venture. I don't care what you call it. There needs to be some confidentiality agreement between the parties, because that is the point of a trade secret. You're only going to share it with those that are contractually bound to you, because your only protection is if they steal it from you. So if that's your facts, right? If that's your facts, otherwise it doesn't matter, right? There could be 50 other competitors that are doing it the same way as you, but because it's a trade secret, there's nothing you can do. But
what I did is a layer of agreements. So the first one is like IP protective NDA. So, says you won't disclose, we won't compete. Yeah. But then I ultimately have a managed intellectual partnership, where essentially I own it, but they're partnering it in return for a license to use it for their particular purpose.
Yeah.
So I created.
I get it. It sounds like you have all the agreements. It sounds like the facts are on your side, that they stole it from you. You need to sue those people. It's the only thing you can do right now.
And then in terms of damages, what I did was I said, essentially, it's 10. If we do business after this point, because I have a very low price point coming in, it's 10 grand a month for 60 months and $3 million at the end through a liquidity event. So I wanted to do like give them a liquidated damages right up front. I say, if you're not prepared to do this deal with me, then you're not getting my information. So I figured that having a defined number at the beginning was really important to establishing damages later. Like, you went into this thing knowing that I expected this, right? So, but I haven't represented clients in 30 years, so you have. So I wanted to really know from your perspective, what, like, if you thought there's anything more I could do or should do.
It doesn't. It sounds like you've probably done it all, but maybe we should probably talk offline just to kind of some of the specifics. But it sounds like you've done everything you had to do and the right way.
Okay.
You just have to
Thank you.
support. You're welcome. Any John, our speaker, any other kind of words of wisdom for everybody on the call?
David, I think he jumped off. He left a message that he had to jump off.
Yeah, he was traveling. Okay, no worries.
Hey.
I'll ask him to share some words of wisdom in the recap that we send with the video. Yes.
It's great to see Cheryl. I was on America's Big Deal as well. Episode.
I remember.
It was unbelievable experience. I love to see the success. I think what you're doing on Amazon is really unique. Getting these infringers to go into licensing deal. It's really unique, and it just goes to show that you got David, who's a unique patent and trademark attorney, and I haven't heard of anything like that. Everyone I know that's being infringed upon on Amazon, it has to fight. But the Apex program I know is great, and transparency, I believe, has also helped out that program. So great job. I definitely want to follow up with you. So if you don't mind throwing your email in the I got it. There it is.
Sure. That's it. And I do want to say that, and I shared this with David at first, is that just like you, Chris, I put together a course because I would get so many people contacting me. How did you start a product? How did you find manufacturers? So I starting a course called how to bring your product idea to market, and we're doing a challenge on September the 18th. So most of you already have your products, but if you know anyone with an idea who needs help just going from concept to prototyping to manufacture, then you can check that out and join me for the free challenge, which will lead into a paid course if you're interested. But so Chris, yeah, I'd love to talk to you with what you're doing too. We can do something together.
Yep, David can. I got your email, so I'll reach out to you. I just realized that. Sorry. Hey, David. Okay. As always, you throw together great presentations. You bring the best speakers, and this is a lot of work. I want everyone to know, putting these meetings together, David does it on his own time, and you got to say, great job, David. Always.
I appreciate that.
Yeah,
Agreed. Agreed.
Thank you very much. I appreciate that. Thank you for all coming, because it wouldn't happen if you weren't.
Thank you.
So we will end it. It's been a bit. Definitely reach out to each other and try to work with each other. There's some good kind of resources here. And our next ESS is in September, the last Thursday of September, which is September 28th. And it's all about, come on, we cannot ignore this. It's all about artificial intelligence and ChatGPT and all of the intellectual property issues that brings up, and how to manage that, what the government thinks about it. It's definitely going to be an interesting one. If you've never used any of the AI or ChatGPT, we will be kind of demoing it live to show you. We have like some fun exercises for everyone to do to kind of see just how kind of quote unquote unreliable it is. But that's as much as I'll say. Everybody have an awesome Labor Day. Enjoy the day off. Thank you so much, Cheryl and John, and thank you for all your questions. And we'll talk soon.